Welcome to the WG University Weber Gallagher series of educational programs. This is our employment webinar series. I am Christina Abreu and I am presenting today with Tracy Walsh from our Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is what employers need to know in the era of the Me Too movement. Let's get started.
So what do employers need to know now that we are in the year 2019 and the Me Too movement? The Me Too movement, as most of you are aware, is a movement against sexual harassment, sexual assault, and sexual violence. In response to this movement, there have been changes in the law in some states, and there also has been a heightened awareness for employers in response to the Me Too movement. And these are the items that we are going to talk to you about today. One of the new laws, which is considered a direct response to the Me Too movement, is a new amendment to the New Jersey Law Against Discrimination. In connection with the law against discrimination, we are also going to be providing you with an overview of sexual harassment. We are also going to be discussing a new harassment prevention law that is in effect in the state of New York. And we will also be discussing critical components of properly conducting investigations of harassment complaints. First, let's talk about this new amendment to the New Jersey Law Against Discrimination. This law, which is often referred to as LAD, applies in the state of New Jersey to employers in the state of New Jersey. And this law has been in effect for several years, but the amendment itself just became effective on March 18th of 2019. In general, the law against discrimination in the state of New Jersey prohibits harassment, discrimination, or retaliation against several types of protected groups, such as gender, race, age, etc. The amendment to LAD will now impact employment agreements as well as settlement agreements. In employment agreements, there are often agreements that are known as non-disclosure agreements or NDAs. And in settlement agreements, where there is a settlement of claims under the New Jersey Law Against Discrimination, there may be confidentiality provisions. This amendment now impacts those types of agreements, NDAs and/or confidentiality provisions in employment contracts and in settlement agreements. What is important to keep in mind with regard to this amendment is that it is not uniquely applied to sexual harassment claims. It pertains to all claims of discrimination, retaliation, or harassment under the LAD. How does the amendment under LAD affect or impact employment contracts? The amendment states that any provision in an employment contract that has the purpose or effect of concealing the details relating to a claim of discrimination, retaliation, or harassment is against public policy and is unenforceable. So for example, in an employment contract between an employer and an employee, if there is an NDA and it conceals the details relating to a claim of discrimination, retaliation, or harassment, this amendment provides that that type of provision is against public policy and therefore unenforceable. Also, the amendment states that any provision in an employment contract that waives any substantive or procedural right or remedy pertaining to claims of discrimination, retaliation, or harassment is against public policy and is unenforceable. What does that mean? So for example, if there is a provision in an employment agreement where an individual is waiving any actual substantive right pertaining to any such claim, or a procedural right such as how or under what method the claim itself can be pursued or adjudicated. Also, an employment contract cannot have a prospective waiver of rights or remedies under the LAD. There are certain types of agreements which the amendment to LAD does not prohibit. For example, it does not prohibit non-compete agreements. It also does not prohibit non-disclosure agreements of proprietary information. So for example, NDAs with regard to trade secrets. A question does arise with the amendment to LAD as to its impact on the use of arbitration agreements for claims of discrimination, retaliation, and harassment. When we consider the Federal Arbitration Act, which could be argued to preempt the state law. How this amendment will impact arbitration agreements in the state of New Jersey with regard to claims of discrimination, retaliation, and harassment is expected to come up in the courts as we move forward with this new law. How does the amendment apply to settlement agreements? So similar to employment contracts, if there is a provision in a settlement agreement which has the purpose or effect of concealing details relating to a claim of discrimination, retaliation, or harassment, then that is against public policy and is considered unenforceable. Therefore, if there is a settlement agreement between an employee or former employee and employer that resolves any claims of discrimination, retaliation, or harassment under the LAD, then that confidentiality provision is not to preclude the individual or employee from disclosing such claims. The amendment also provides that the employer must include a bold, prominently placed notice in the agreement. That could be a notice that is placed in bold font or capital letters, for example. And the amendment itself does state exactly what that notice should say. And it should state that although the parties may have agreed to keep the settlement and underlying facts confidential, such a provision in an agreement is unenforceable against the employer if the employee publicly reveals sufficient details of the claim so that the employer is reasonably identifiable. So if there is a confidentiality provision where the parties agreed to keep the underlying facts confidential, then this notice provides that if the employee publicly reveals enough details that the employer is reasonably identifiable, then that confidentiality provision is no longer enforceable against the employer. The amendment to LAD also prohibits retaliation against a person who refuses to enter into an agreement that contains a provision that is against public policy and unenforceable under the amendment. And it also allows for a private right of action for violation of the amendment in state court. So in addition to LAD allowing a private right of action for a claim under the law itself, this amendment also allows a private right of action with respect to just the amendment. And all remedies that are available in common law tort actions, as well as reasonable attorney's fees and costs, are available to the prevailing plaintiff.
Now we're going to do an overview of what is sexual harassment and how employers can prevent it. What is sexual harassment? There are two types. The first is quid pro quo sexual harassment, and the second is a hostile environment sexual harassment. Quid pro quo sexual harassment is Latin to say something for something. An example is when a supervisor seeks sexual consideration from another employee in exchange for job benefits. It involves an implicit or explicit threat that if the employee does not accede to the sexual demands, he or she will lose their job, receive an unfavorable performance review, be passed over for a promotion, or suffer some other adverse employment consequence. Some examples of quid pro quo sexual harassment are spend the night with me and I will promote you. Or in contrast, if you don't spend the night with me, I'll fire you. Next, we have hostile environment sexual harassment. This is where the complaining party must show that the conduct by an offender would not have occurred but for the employee's gender, was severe or pervasive, to make a reasonable person object to the conduct and believe the conditions of employment were altered and the working environment was hostile or abusive. A hostile work environment must create an offensive working environment, and the focus is on the harasser's conduct and not necessarily on the victim's injury. The definition of severe or pervasive can be a pattern of misconduct. So this would include circumstances such as hearing sexual jokes, seeing pornographic pictures, and receiving a repeated invitation to go out on dates. Or it can also be a single severe incident. For example, one employee talks to another about sexual activities and then touches her in an offensive manner. The standard of review is the reasonable person standard, and that's used to evaluate the harasser's conduct. And so here are some examples of sexually harassing conduct. There's verbal remarks, dirty or offensive jokes, sexually explicit stories, comments about an employee's dress or body, inquiries about a person's sex life, or suggested remarks. There's also sexual propositions, repeated invitations for lunch or dinner dates, sounds of kissing, whistling, or smacking lips, demeaning remarks, making comments about women belonging in the kitchen or calling a person honey or baby, and of course sexual emails or letters with inappropriate jokes or forewords. It could also be considered physical conduct as well, and that would include hugging, touching someone's body, hair, or clothing, bumping or brushing up against a person, kissing a person, massaging, blocking one's movement, or smelling one's perfume. There's also nonverbal or visual examples, sexually explicit photographs, drawings, or cartoons, graffiti, staring at someone, exposing oneself, facial expressions like winking or blowing kisses, licking their lips, sexual hand gestures, or even gag gifts that are sexual in nature. Prevention is key in this case. These are the tools that every employer should have in their toolbox. They basically serve as a shield for the employer when they are faced with litigation alleging sexual harassment. This includes an updated employee handbook, updated employment policies for anti-harassment specifically, to create a clear employee complaint policy, and to conduct annual anti-harassment training. The importance of having updated workplace policies is that it provides the employer an affirmative defense to vicarious liability by showing that the employer exercised reasonable care to prevent and promptly correct any harassing behavior, and that the employee unreasonably failed to take advantage of the preventive procedures put in place by the employer. How do employers show that it exercised reasonable care? Well, it must show that it has the anti-harassment policy with a clear complaint procedure. Not only do you have to have the policy, but you have to implement the policy and have your employees trained on the policy as well. The employer must take all complaints by employees seriously and conduct a prompt and thorough investigation of their complaints. Once the complaint is completed, then it must take appropriate remedial action when necessary.
And as Christina stated, with prevention being the key and the suggestion that training be conducted on an annual basis, there actually has been a law recently passed in the state of New York that specifically deals with the prevention of sexual harassment. This new sexual harassment prevention law in New York State became effective on October 9 of 2018. It requires every employer in New York to establish a sexual harassment prevention policy. So if you are an employer who does not have a sexual harassment prevention policy in the state of New York, then you need to implement one. Employers who have a sexual harassment policy now can go visit the New York Department of Labor's website for a model sexual harassment prevention policy and compare it to theirs in order to make sure that it meets or exceeds the minimum standards of model policy. And of course, if the employer does not have a policy at all, then certainly going to the New York Department of Labor's website will ensure that an employer can find out what those minimum standards are and adopt a model policy that is in compliance with the new law. According to the New York state law, the policy should be distributed to all employees in writing or electronically. It should be posted where it is readily available to all employees. And employees should be required to acknowledge receipt of the policy in writing. So once the policy is disseminated, the employer must require that the employees acknowledge receipt by signing that they have read and understood it. And those acknowledgements should be returned to the Human Resources Office or the office which is maintaining and should be maintaining the records with regard to the policy and its acknowledgements. Also, under the New York law, when it comes to the training, the prevention training of sexual harassment, all employers in New York must provide sexual harassment prevention training to their employees. How can this training be effectuated and be in compliance with the New York state law? The training is required to be interactive. That means that employees must be allowed to ask questions, and the employer must have a representative or representatives available to provide answers in a timely manner. This, of course, can be done in person, and when it's live in person, then employees and the trainers can obviously immediately interact in person. However, the law does allow for the training to be conducted by phone or online or via a webinar or a recorded presentation. If the employer does choose to conduct the training in any way other than in person, then in order to comply with the law, the employer must make sure that a representative is available via phone or in person during the time that the training is actually taking place so that employees can ask questions. Also, and finally, with regard to the New York state law, all employers must adopt and provide the sexual harassment prevention training by October 9 of 2019.
So when an employee makes a complaint of harassment, the employer is obligated to complete an investigation. The investigation can be completed by an internal investigator. It can also be an external investigator, or you can have outside counsel complete the investigation. Once an investigator is chosen, the investigator will meet with the complainant, the witnesses, and the alleged harasser. They will then review any and all physical evidence, which includes the written complaint, emails, letters, videos, texts, or photographs, and they'll try to keep the internal investigation as confidential as possible. And then once they finish meeting with the witnesses and reviewing all the physical evidence, they'll prepare and finalize an investigation report. The investigation report will include the nature of the complaint. It'll include a summary of the discussions or interviews with the complainant, alleged harasser, and all other witnesses interviewed. It'll also indicate what the relevant physical evidence was that was reviewed and contain its factual findings. A sustained or corroborated allegation is when an investigation reveals a preponderance of the evidence in support of the allegation, or it will be deemed not sustained, which is when an investigation reveals there was not a preponderance of the evidence in support of the allegation. In closing the investigation, the investigator will share its findings with either the high-ranking executive, HR, or committee that they were working with. They will advise the complainant and alleged harasser of the outcome of the investigation and any remedial action that will be taken. Remedial action would include additional training or disciplinary action up to including termination. And these documents related to this remedial action should be placed in the alleged harasser's employment file. The report should be kept separate in a confidential file, and any evidence that was reviewed with the investigation should be preserved as physical evidence. The investigation report is discoverable if legal action is filed.
Thank you for attending our webinar, What Employers Need to Know in the Era of the Me Too Movement. You can learn more about this program and all other Weber Gallagher events by visiting our website at wglaw.com. Thank you.